Hello, and thank you for joining us today for the latest in our LexisNexis Legal Talk podcast series. My name is Michael Contudis, and I'm the Senior Legal Writer for Practical Guidance Dispute Resolution. Today, I'm privileged to be joined by Matthew Peckham of List G Barristers for this discussion called Civil Penalty Proceedings 101, a practical guide for commercial litigators. Matthew's a barrister at the Victorian Bar, specialising in civil penalty proceedings and other complex commercial and regulatory matters. He's previously worked at ASIC and the Financial Services Authority in London, and he has a national practice acting both for and against Commonwealth and state regulators. Matthew's also an author for Practical Guidance Dispute Resolution, having authored our recently published topic concerning practice and procedure in civil penalty proceedings. Welcome, Matthew.
Thanks, Michael. It's good to be here.
Okay, so Matthew, before we get into the more practical side of things, I think it might be helpful if you could give our listeners some context and give them a brief explanation about what civil penalty proceedings actually are.
Okay. Well, a civil penalty is a penalty imposed by a court in a civil proceeding for a breach of the law. It isn't a criminal offence, so nobody goes to jail, but the penalty might be millions or perhaps tens of millions of dollars. They're typically brought by a regulator, like ASIC or the ACCC. There is one exception to that, in that under the Fair Work Act, a penalty can be sought by a private party, like an employer or a union, but
Right.
that's not what we're talking about today.
Right, thank you. And so I suppose it's a worthwhile question. Are civil penalty proceedings a recent development or phenomenon, or?
Yes and no. They've been around since Federation, so one of the earliest High Court cases dealing with them is from 1904, but they've become much more prominent recently. Civil penalties were introduced in the trade practices regime in the 70s, and then in the corporations law regime in the 90s. But really, in the last 10 or 15 years, they've been expanding into all sorts of areas, and the penalties are becoming much, much higher as well. Perhaps 10 or 15 years ago, almost all civil penalty proceedings were conducted by a small handful of regulators. So, the usual suspects, ASIC or the ACCC or the ATO. But now they've been rolled out much more widely across the Commonwealth and also in state legislation in Victoria. So that when you deal with a civil penalty proceeding now, yes, you might be dealing with ASIC or the ACCC, but you might also be dealing with the Australian Energy Regulator, or with AUSTRAC in relation to money laundering issues, or with the Essential Services Commission in Victoria.
Right, so that's pretty interesting. And from your perspective, I'm wondering what you think is driving that development, that expansion of the civil penalty sort of actions taken by various regulators. Is there a reason for it?
Yeah, well, there's a few reasons for it. The first reason is they're an attractive tool for regulators, and I like to distinguish them from the criminal prosecution here. They allow companies to be prosecuted and fined for commercial wrongdoing much more easily and with greater certainty than if you're running a criminal prosecution. The onus of proof is lower, so you're proving up the balance of probabilities as opposed to beyond a reasonable doubt. There are other procedural advantages. You can settle a civil penalty case and propose an agreed penalty to the court, which is something you can't do in a criminal prosecution. The main advantage I see in running a criminal prosecution is that you can use it to put someone in jail. But if the wrongdoer is a company and you can't put it in jail, and instead you want to give it a very big fine to stop it from breaking the law in future, then a civil penalty is usually a much more attractive option. There's another sort of reason, which is a bit more thematic, I suppose, in that civil penalties are really well suited to strict liability and regulatory type misconduct. In the criminal law, there's a real focus on a person's state of mind and their moral culpability, whereas in civil penalty regimes, you're often dealing with strict liability type offences. You're not really that concerned with their state of mind or their moral culpability. You're really concerned with how they've been behaving. What you want to do is enforce certain standards of conduct in business or in other, areas of regulation. And the way we do that with civil penalties is to give regulators very broad powers to investigate wrongdoing and then allow them to bring proceedings fairly easily to punish wrongdoing by way of imposing a deterrent. And the penalties need to be high enough to deter people from breaking the law, but not so high as to be, totally oppressive to the person in question. And as our economy becomes more sophisticated and our society becomes more complex, we need to have more of those regulatory type laws, which are a little less concerned with moral culpability, a little more concerned with making sure everyone follows the right rules.
Excellent. Thank you, Matthew. And so practical now. You're a practitioner listening to this podcast today. Why do you think it's important for that practitioner listening to be prepared to deal with a civil penalty proceeding?
Yeah, this is something I speak on quite regularly. There's really three key reasons. Commercially, from the practitioner's point of view, it's important because we're seeing a lot more civil penalty proceedings now in a broader variety of areas. And if you're a trusted advisor to a client that's facing a civil penalty proceeding, it really is commercially important for you to be able to assist them through that process. From your client's perspective, it's important because the penalties can be very large. And more fundamentally, the conduct that's often alleged to be unlawful can sometimes go right to the very heart of your client's business, how it does its trading. So it raises a whole range of broader strategic issues. And finally, just from a technical legal perspective, civil penalty proceedings can be quite different from conventional civil or commercial litigation. And it's important for lawyers to be aware of those differences. So the starting point is always that they're fundamentally civil in nature, but they take on certain attributes that are perhaps more associated with criminal prosecutions, just by way of the nature of the proceeding it is, and sometimes the privileges the respondents might have. So if you're very experienced in purely commercial litigation, that's great. It's a great starting point. But if you applied exactly the same approach to a civil penalty proceeding, you might end up getting in some trouble. You just need to know where to steer a bit differently in a civil penalty case.
Right. I mean, that's really interesting, the way you say that, there are certain attributes that you would more commonly associate with a criminal prosecution. Can you expand on that a little bit and describe for our listeners maybe some of the more concrete ways a civil penalty matter sort of can be compared to a criminal matter?
Yeah. Well, firstly, there's a power imbalance. It's the same sort of context where you're acting for a private party and you're opposed to the power and authority of the state. In a civil penalty case, often the regulator has even more significant advantages than a criminal prosecutor might do. And that's because even though the defendant might be a big corporation and have be very, very well resourced and so on, the regulators will have broad powers to obtain documents, to examine people under oath, and to require written answers on notice. So they've got very strong powers to actually investigate wrongdoing. Secondly, the consequences and the strategy are a bit different in a civil penalty case to, say, like a commercial damages claim or a commercial contract claim. If it looks like the regulator will be successful against your client in a civil penalty case, then you might get a substantial discount on penalty if you concede the case early, a little bit like pleading guilty in a criminal case.
Yep.
On the other hand, you might want to fight it as vigorously as possible because you might be defending some practice that's really critical to your client's business. And, if it concedes that it's unlawful or it's decided that it's unlawful, that'll have a really significant knock-on effect apart from just the penalty itself. And again, unlike a private commercial case, you can't just settle it privately. You can resolve a civil penalty proceeding by agreement, but that'll be a matter of public record, and the penalty itself will have to be actually imposed with the authority of the court.
Right.
There's sort of one final distinction, which is it really comes into play only if you're acting for a natural person. Civil penalty proceedings are a little more often used against corporations. They can still be used against individuals. Natural individuals have what's called the privilege against self-exposure to a penalty. It's very similar to the privilege against self-incrimination. It operates in similar ways. What it means is they might not need to file a defence, or they might not need to file one until quite late in the piece in a trial. They don't need to foreshadow what their evidence will be up front. They don't need to make discovery. And in that sense, they're in a similar position to a criminal accused. So that's a little unusual if you're coming at this from a civil litigation point of view. And it's important to be aware of that privilege and what it might mean for your strategy.
Thanks, Matthew. I mean, I just want to be very clear here. If your in-house counsel Are you looking to a criminal practitioner who specialises in maybe white collar crime, or are you going to look at your, commercial practitioner? Who are you going to if you've got one of these matters on your desk? What are they best suited to?
Yeah, it's a good question. And look, there will be people who cross over into both of those fields, all of those fields. To my mind, they're more suited to commercial practitioners, but preferably someone who has a little bit of experience or understanding of the particular aspects of civil penalty proceedings. They're civil in nature. They're governed by civil procedure and the civil rules of evidence, and not by criminal procedure and the criminal rules of evidence. The onus of proof is civil, and that has a very big impact on the strategy one employs. The other thing is their subject matters often very commercial in nature, and therefore more suited to a commercial litigator, in the sense that you might be talking about, the intricacies of some sort of financial transaction or the energy markets or something of that nature. So, or, economics in a competition law case. So that sort of lends itself to a commercial practitioner as well.
Thank you. So let's use our imagination for a moment and put ourselves in the position of a lawyer at a firm, maybe a large firm. You handle general comm lit matters for a large corporate client, and one day you've got the MD of your client calling you, telling you that, for example, ASIC has issued them with a notice to say that it's investigating contravention of a civil penalty provision, and she wants to know, what do you do next? What is your practical advice to that client?
Yes. Thanks, Michael. Happily, that's not too big a stretch for me, because that's exactly what I was doing before I came to the bar, except for the point where I was actually at ASIC issuing these notices.
Right.
Well, the first step is take a good look at the notice. If the notice is valid, your client will need to comply with it. There's just no getting around that. But in order to identify whether the notice is valid, you need to look at the statute it's issued under, see what is the extent the regulator's powers to investigate. Has the notice been validly issued? Does it exceed ASIC's powers? It's very common at the start of an investigation for ASIC or any other regulator to require your client to produce documents, or to say it's going to examine a number of your client's staff, or to require it to answer some written questions on notice. And depending on the regime, those are all things a regulator can do. The second thing is really a bit more strategically identify what are the nature of the regulator's concerns. This will let you advise your client and start thinking about what to do next. These notices usually are required to set out what provision the regulator thinks might have been breached. And once you've worked that out, you can then work out, well, what are the maximum penalties if any contravention is made out? What other sort of orders might ASIC or the other regulator potentially seek if it comes to a court proceeding? And it can be helpful at this point, possibly, to engage with the regulator and find out where they're coming from, so you can start considering how your client will respond. And this is where I get to my third point, which is really about start thinking about strategy and start getting some instructions. Because you need to work out, is this a case where your client should be vigorously resisting it and denying liability, and possibly, being a little less cooperative in its responses to the notices? Or should it be more cooperative because it's potentially going to take the view that it'll concede its contravention, and it's really arguing about what the penalty should be and trying to reduce its exposure to the penalty and get ultimately a discount for cooperation, which again is similar to what you'd see in a criminal proceeding, where you'll get a lesser sentence if you plead guilty. The other strategic issue that comes up is, which needs to be considered early on, is the conduct, is this sort of a one-off transactional type breach, or is the conduct some sort of ongoing conduct that your client's still engaging in?
Yeah.
Because if it's something that's central to its business, then it's not just one penalty you're worried about. It's really about what's it going to do going forward? How's it going to manage this issue with the regulator?
Well, that makes sense to me. And I suppose then, moving forward in the timeline of this imagined matter that you've got, the investigation's concluded, you're actually served by ASIC with a civil penalty proceeding. What do you do then? What are you thinking about then?
Yes, well, you've got ASIC's pleading or the regulators pleading, so you should then know what the nature of their concern is and be in a better position to advise about penalty. Your client might have already taken some steps to address those things. They might have perhaps stopped engaging in the conduct in question if they think it's perhaps a little risky or indefensible. Or your client might be really digging in its heels and saying, actually, no, I think this is defensible, what I've been doing, and we're going to defend it and say, no, there's no breach here. But it's important to form that view early on. Depends on both the merits of ASIC's case and also how much your client has at stake if it loses, which is not just the penalty itself, but as I said, all those potential flow-on consequences. Sometimes you don't know exactly what amount of penalty your client might be potentially exposed to because there might be sometimes in cases where there are hundreds or thousands of breaches, the theoretical maximum might be billions of dollars. And the court has to sort of go through a process to work out, well, what's the realistic maximum? It can be perfectly reasonable to ask the regulator on a without prejudice basis what sort of relief it's likely to be seeking if its case is made out. And that'll inform your client's position. And there shouldn't be any real hesitation to make that sort of inquiry. It's just like if you're dealing with a damages claim, you want to know if is it a $10 million damages claim or a $500,000 damages claim. You just need to know what you're dealing with. And finally, as I mentioned before, the thing to always keep in mind in these cases is your client a corporation or is it a natural person? If it's a corporation, the proceeding will probably look much more similar to a conventional, civil or commercial proceeding. If you're dealing with a natural person, you might be saying, well, no, actually, I'm not going to put on a responsive defence until I've seen all of your evidence. I'm going to, rely on my privilege against self-exposure to a penalty.
I mean, that makes a lot of sense to me. And I mean, you did say, you do have the option of reaching out on a without prejudice basis to suss out what sort of penalty is being proposed. I take it from that and from what you said earlier that it is possible to negotiate a settlement of these types of proceedings at certain stages.
Yeah, that's right. And that's another critical difference between these and a criminal prosecution. They're very regularly sent to mediation or referred to mediation by the court. Strategically, you can certainly settle them. It might be, it's a pure settlement where you're saying, look, I will admit to liability if we can agree that we'll jointly propose a penalty of $1 million, but if I can't agree on penalty, then I'm going to defend it and deny liability. That's an option that's available to you. You might simply choose to concede liability regardless of whether or not you come to an agreement with the regulator, because then you can still have an argument in court at what the penalty should be, even if you're not actually conceding, even if you're conceding liability.
Yep.
In civil penalty proceedings, one sort of critical thing to realise is that settlement's not a purely private matter. A penalty is a sanction imposed by a court. It's not just a payment between parties. So in order to actually mechanically affect a settlement, the regulator and the respondent prepare a statement of agreed facts and joint written submissions to the court. And they say, oh, Your Honour, we agree that this is what happened and that there's been a contravention, and we jointly propose that this amount be imposed as a penalty. And that the court will then consider for itself whether it thinks that penalty is appropriate. Generally speaking, it will usually approve most penalties because it's in favour of certainty and in favour of settlement. But it's not a rubber stamp by any means.
Yes, right. So if you are trying to settle one of these sorts of matters, I guess it'd be helpful for our listeners if you could set out maybe some of the forefront considerations that you should have in your mind, the big picture considerations.
Yeah. So the first one is, just what are the pros and cons of admitting liability versus resisting? So if your client's conduct is admitted or it's found to be unlawful, is that going to be a one-off issue that it can put behind it after this? Or is that going to have some ongoing consequences for how it does its business? On the other hand, if it admits liability, there's an advantage to that because an admission and cooperation we regard as a mitigating factor. So any penalty that's imposed will usually be significantly less than if it had resisted the matter all the way through trial.
Yep.
The second thing is, this is something I touched on a bit earlier, identifying what is your client's maximum realistic exposure. So what's the maximum penalty, and just walk through what matters are relevant to determining what the actual penalty imposed might be. There's a fairly widely accepted list of relevant matters known as the French factors after Chief Justice French that are commonly applied. So I need to walk through those and see, well, what sort of exposure are we likely to have here? And the third thing is putting aside the penalty itself, just identifying whether any other relief is being sought. In these cases, some regulators might have a whole toolbox of other sanctions they can seek from a court. They might be injunctions, community service orders, orders that people publish a corrective advertisement, for example, where there's been some sort of misleading advertising, and other sorts of remedies. So the regulator might be seeking those as well. And those are also the sorts of things that can be discussed in settlement discussions. You might say, well, I'll agree to this penalty, but I won't agree to publishing that corrective advertisement.
No, fantastic. That makes a whole lot of sense, and I think that's very helpful. I guess in summing up then, Matthew, if you had to distill your top 3 takeaways that you wanted our listeners to bear in mind in the event that they have a client involved in a civil penalty matter, what are those top 3 takeaways for you?
Well, the 3 things I think are most important to keep in mind is 1, your strategy, 2, the boundaries and scope of the law and the regulator's powers, and 3, what can be done in mitigation. First off, strategy. These are cases that really need to be focused on strategically from the very beginning. You need to have to think about what's the regulator trying to achieve, what should your client be focusing on, particularly because they can have those wider ramifications for your client's business. You don't need to form a view immediately as to whether you're going to admit liability or contest it, but the sooner you can make that decision, generally speaking, the better. Because if there's a chance that your client is going to concede or be found liable, it's better to perhaps do that early and get the maximum available discount for your cooperation. And even if you're going to resist liability, if there's a chance that your client's exposed to a penalty, there might be some action it can take to improve its position in any event. Like it might, it might not concede that what it did was unlawful, but it might still be willing to change its practices a bit so they're more clearly within the scope of the law. And finally, or secondly, I should say, sorry, what are the boundaries and scope of the law? So think about these things are always driven by statute. So is the regulator acting within its powers in relation to the investigation? How should the civil penalty provision be construed? The issue here is really, is your client's conduct lawful or unlawful? And there's a legal construction question in there. And in particular, or as well, I should say, what are the boundaries of your client's privilege against self-exposure to a penalty if it's a natural person that has that privilege? And what does that mean for the conduct of the proceeding? The third and final point is, as I said, think about mitigation, particularly outside the boundaries of the proceeding itself. So if your conduct's alleged to be unlawful, what does that mean on an ongoing basis? And can your client do anything to perhaps mitigate against that risk? Is there any risk it might be exposed to claims for damages from its customers or like a class action if the conduct's found to be unlawful, and that's conduct involving third parties? Does it need to notify any insurers to mitigate that risk? Are there any potential disciplinary or licensing consequences? Perhaps these matters are often reported in the media, and it might be there's some strategic steps your client can take to mitigate its exposure there as well, or at least properly prepare for what might be coming down the line.
Terrific, Matthew. That's really, really helpful, I think. And I know you're busy. I'm reluctant to take up too much more of your time. I think this has been a really fascinating discussion, and your insights have certainly been illuminating for me, and likewise, I'm sure they're going to be illuminating for many of our listeners. I kind of knew that already because I've read and published the new civil penalty proceedings topic that you have authored for us for practical guidance dispute resolution. So to all our listeners out there, if this discussion has been illuminating for you, that topic authored by Matthew is full of similar insight and expertise. So I encourage you to check it out. Matthew, thank you so much again for your time today.
Thanks, Michael.